Welcome to this presentation on unpaid internships in Massachusetts. Still legal in 2026? The short answer is yes, but with strict conditions. As stated on the official website of the U.S. Department of Labor at dol.gov, the Fair Labor Standards Act requires most workers to be paid minimum wage, unless a specific exemption applies. Massachusetts courts follow the First Circuit's primary beneficiary standard, established in the case of Benjamin versus B&H Education in 2017. In Massachusetts, minimum wage in 2026 is estimated at around $15.50 per hour, more than double the federal rate of $7.25. This means the cost of misclassifying an intern is especially high in the Commonwealth. Throughout this presentation, we will break down the 7 factors of the primary beneficiary test, explain Massachusetts-specific legal risks, and give you practical guidance. You can find the full text of the Fair Labor Standards Act by scanning the QR code on this slide. Before we dive into the internship test, we need to understand the baseline. According to the Fair Labor Standards Act of 1938, specifically Section 6 found at Title 29 of the United States Code, Section 206, for-profit employers must pay at least the federal minimum wage, which is $7.25 per hour. Section 7 of the FLSA requires overtime pay at 1.5 times the regular rate for any hours worked beyond 40 in a single work week. The FLSA defines the term employ very broadly, as to suffer or permit to work. This definition catches many misclassified workers, including interns. In Massachusetts, the state minimum wage in 2026 is estimated at around $15.50 per hour, as governed by Massachusetts General Law, Chapter 151. Section 1. Employers must pay whichever rate is higher. So for Massachusetts employers, that is around $15.50 per hour. So what is the test that courts use to decide if an unpaid internship is legal? In Massachusetts, the controlling precedent comes from the First Circuit Court of Appeals in the case of Benjamin versus B&H Education, decided in 2017. This decision adopted what is called the primary beneficiary test. The test is a flexible, holistic balancing test with 7 non-exclusive factors. No single factor is determinative. Courts weigh all 7 together to assess the economic reality of the relationship. The core question is simple. Who is the primary beneficiary of the internship? The intern who gains education and experience, or the employer who gets free labor? As explained in the Department of Labor's fact sheet number 71, available at dol.gov, the 7 factors cover compensation expectations, educational training, academic credit, schedule accommodations, duration, staff displacement, and job guarantees. Now let us examine each factor in detail. Starting with Factor 1. This factor asks whether both the intern and the employer clearly understand that there is no expectation of compensation. A signed written agreement from both parties, explicitly stating the unpaid nature, is the strongest evidence for this factor. Promises of future paid employment, stipends, or in-kind benefits can all be construed as implied compensation under the FLSA. If the employer later provides any payment, even a small stipend, the analysis shifts dramatically toward employee classification. The case of Glatt versus Fox Searchlight Pictures from the Second Circuit in 2016 illustrates this well. Interns who expected academic credit but received no formal instruction were found to be employees. A clear, signed agreement is your best protection. Factor 2 examines whether the internship provides training that resembles what the intern would receive in an educational environment. Structured mentoring, rotation through departments, skill-building exercises, and regular feedback all support the educational nature of the program. The key question from the Benjamin case is the intern learning new and transferable skills or simply performing repetitive tasks that benefit the company? In Benjamin itself, the First Circuit held that students who received hands-on training in a structured educational program at a for-profit cosmetology school were properly classified as primary beneficiaries. Massachusetts hospitals and research labs must be especially careful. Clinical placements must show genuine educational benefit. Factor 3 focuses on whether the internship is tied to the intern's formal education program through integrated coursework or the receipt of academic credit. When a college or university awards academic credit for the internship, it strongly supports unpaid status under the FLSA. Massachusetts universities, including Harvard, MIT, Boston University, Northeastern, and Boston College, heavily rely on academic credit frameworks for their internship programs. The integration of coursework, faculty oversight, and alignment with the academic calendar all support the educational purpose. However, an internship with no academic component, no credit, and no coursework connection leans toward employee classification and minimum wage obligations. Factor 4 asks whether the internship accommodates the intern's academic commitments by corresponding to the academic calendar. The program should not require interns to skip classes, miss exams, or fall behind on coursework to participate. Flexible scheduling around semester breaks and exam periods shows the program is designed for the intern's benefit, not the employer's convenience. The Department of Labor states that the duration should correspond to academic terms or defined learning periods, not indefinite staffing needs. Massachusetts employers should design their internship schedules to align with the academic calendar of the many colleges and universities across the state, especially in the Boston area. Factor 5 examines whether the internship has a limited duration tied to specific learning objectives. Once the intern has acquired the intended skills and knowledge, the program should end. Continuing beyond this point suggests the employer needs ongoing labor rather than providing education. Courts view open-ended or indefinite internships with suspicion, as they often indicate employment, not education. A defined end date tied to a semester, a project, or specific learning outcomes strongly supports unpaid internship classification. The Department of Labor emphasizes that the duration should be limited to the period in which the internship provides the intern with beneficial learning. Factor 6 is often the most critical factor. It asks whether the intern's work complements rather than displaces the work of paid employees. If the intern performs tasks that a paid employee would otherwise do, such as answering phones, filing, data entry, or customer service, the employer is benefiting, not the intern. This suggests employee status. However, if the intern works alongside paid staff on projects that provide educational benefit without replacing anyone, the program is more likely legitimate. In Benjamin, student interns at a cosmetology school worked on real clients under supervision. The First Circuit found they complemented rather than displaced paid staff, and the educational benefit tipped the balance. Factor 7 is the final factor. Both parties must clearly understand that the internship does not entitle the intern to a paid job afterward. If the employer implies or promises a paid position after the internship, the program may be reclassified as paid on-the-job training. Clear written agreements, signed by both parties, stating there is no commitment to hire after the program are essential protective measures. Internships marketed as probationary periods or trial employment are highly likely to be classified as employment by courts. This factor reinforces the temporary, educational nature of a legitimate unpaid internship. Now let us look at why unpaid internships specifically thrive in Massachusetts. The Commonwealth has a unique combination of factors that allow unpaid internships to persist at a higher rate than many other states. Massachusetts has over 35,000 nonprofit organizations and over 120 colleges and universities that can legally host unpaid interns under the FLSA volunteer exception. The First Circuit's Benjamin precedent gives Massachusetts employers a clear, flexible framework that, with proper documentation, supports unpaid programs. However, Massachusetts' high minimum wage of around $15.50 per hour in 2026 creates a strong financial incentive for employers to classify workers as interns rather than employees. No Massachusetts-specific internship statute exists